Hi, today we will discuss topic of First Information Report, which is FIR provided under Chapter 12 of CRPC. Under Section 154, we will discuss essentials, object, refusal, mandatory registration, delay in launching FIR, evidentiary value, and related cases. In general, FIR is information about commission of a cognizable offence given to the police officer first in point of time. Whether a particular offence is a cognizable offence or a non-cognizable offence, the same is to be looked in Schedule 1 of the CRPC. As well as information regarding non-cognizable offence is taken down under Section 155 of CRPC, and it is basically called NCR, Non-Cognizable Report. The essentials of FIR is that the information that has been given must be related to a commission of a cognizable offence. Second, that it is to be given to the officer in charge of police station. Third, the information can be given orally or in writing. But if it is given orally, it must be reduced to writing. Third, that it should be signed by the informant. Fourth, that it must be entered into general diary. The form of the general diary will be prescribed by the state government. Lastly, the copy of the FIR should be provided free of cost to the informant. Now we will discuss what is the object of FIR. Well, there are two objects. First and the most cherished one is to set criminal law in motion, and the next is the early information about offence. There's this case called Soma Bhai versus State of Gujarat. The case held that telephonic message stating cognizable offence will also be treated as an FIR. After that, proviso for the Section 154 says that if there's an information regarding the commission of a cognizable offence is given by a woman against whom offences under Section 326A, 326B, 354, 354A, 354B, 345, 354C, 354D, 376 and 376 का पूरा ये जो A से E तक का लाइन है, ये 509 has been given by a woman, ठीक है, or has been alleged to have been committed, the information shall be recorded by a women police officer, ठीक है, or any women police officer, provided further, ये further provide करता है that जिनके person against whom aforesaid offence alleged to have been committed or attempted is either temporarily or permanently or physically disabled, then क्या होगा? Then such information shall be recorded by a police officer. कहाँ पर? At the residence of the person seeking the report or at the convenient place of such person's choice. If the presence of interpreter or special educator is required, then the same shall also be provided. The recording of such information shall be videographed. This proviso basically was added by the amendment of 2013 and was later amended as to Section 376 in regard into 2018. It comes refusal of registering FIR. What if the police officer doesn't register the FIR? What if they deny or they say there is no case made out? Then what is the remedy that can be taken? So if Section 154 Clause 3 provides that if officer in charges refuses to record FIR, then the substance of the same information in regard to the commission of the non-cognizable offence shall be sent to the superintendent of police via post. Now, if he is satisfied that the substance is such that it discloses the commission of cognizable offence, he can do two things. He can either direct an investigation to be held or he can investigate himself the case. Now, what if the superintendent of police also says that we are not registering the FIR or doesn't look into the matter? Then the other remedy is provided under Section 156(3), which is application before magistrate. The aggrieved party or the aggrieved person may present an application in a proper format before a magistrate, and the magistrate may direct an investigation. This is a discretionary power of a magistrate. If he believes or sees that there is a cognizable case made out, he can direct an investigation to be held. The other topic that we are going to do is mandatory registration of FIR. There are two cases in regard to this. First is Lalita Kumari versus State of UP, and the other is State of Haryana versus State Bhajan Lal. Both of the cases says that registration of FIR is mandatory and obligatory if the information discloses commission of cognizable offence. If the case is such where there is a commission of cognizable offence, then the registration of FIR is mandatory. In the case of Lalita Kumari versus State of UP, Supreme Court has held that the police officer is duty bound to register FIR if the information discloses commission of a cognizable offence. The police does not have an option to conduct a preliminary inquiry and then proceed to register FIR. Along with it, State of Haryana versus Bhajan Lal says that the word information in section 154 is not qualified by the term reasonable. By omitting the word reasonable and credible, the intent of the legislature is clear that no discretion is given to the police to launch the FIR, which in general means that the legislator intended to omit the word reasonable. अगर आप सेक्शन 41 में देखें रीजनेबल एंड क्रेडिबल इन्फॉर्मेशन होनी चाहिए, देन ही अ पुलिस ऑफिसर कैन अरेस्ट इन कॉग्निजेबल केसेस. वेयर यहाँ पे लेजिस्लेचर का इंटेंट था इस वर्ड को ऑमिट करना, विच मीन्स द लॉन्चिंग ऑफ एन FIR इज मैंडेटरी. Police cannot conduct a preliminary inquiry, then come to a conclusion. Police cannot perform the role of the court to perform an inquiry in such a manner that it becomes that way. So, the other subtopic is delay in launching FIR. अगर बहुत थोड़ा delay है तो कोई फ़र्क नहीं पड़ेगा. लेकिन अगर इतना लंबा delay है that it is unexplainable या same is not explained sufficiently, तो वो क्या कर सकता है कि प्रोसिक्यूशन के केस को वीकन कर सकता है और फेटल साबित हो सकता है. इन रिगार्ड टू दिस देयर इज अ केस कॉल्ड पलानी वर्सेस स्टेट ऑफ तमिलनाडु, in which Supreme Court has held that the delay in launching the FIR is normally viewed by courts in suspicion because there is possibility of concoction of evidence against the accused. It is the duty of the prosecution to satisfactorily explain the delay and afford plausible explanation of the same. A mere delay in registration of FIR cannot be a ground for throwing away the prosecution case. Long and unexplainable delay may create doubt or raise suspicion as to how the incident has happened. So, agar there is reasonable explanation to the delay, the same can be explained by the prosecution, then it will not be fatal. But if it is unexplainable and it's very long delay, then that may create a fatal effect. The last subtopic is evidentiary value of the FIR. So, there was this case Dwarka Prasad, Chandrika Prasad versus State of Maharashtra, in which it was clearly held that FIR is not a substantive piece of evidence. Now, we will discuss कि categorically देखें कि किसने अगर दिया है आपको FIR, so उसका evidentiary value क्या होता है. If the FIR is registered via non-accused, so in the case of Agnu Nagesia versus State of Bihar, it was held that the statement made in FIR can be used for two things. First for contradiction and then for corroboration. Contradiction is basically given under section 145 of Evidence Act. Corroboration is given under section 157 of Evidence Act. Contradiction is to contradict something that has been said priorly into an FIR. Corroborate something is to support what has been said into an FIR. Basically, contradiction and corroboration is a method to determine the truth under Evidence Act. Contradiction is used to impeach the credit of the witness. So, if the statement supposedly there is a person who comes to the court and gives a statement who's also the informant and is not the accused, and he contradicts his statement. FIR में उसने कुछ बोला and court में he is saying something else, then the same statement can be put forward to him, said, see, this is what you have said in an FIR. And if the same person comes to the court and says the same thing that he has said into the FIR, then the same statement, the same statement made under the FIR can be helpful for corroboration under Section 157 of Evidence Act. Now, what if the FIR has been registered by the accused only? Now, two things can be possible. The FIR is of confessional nature. He comes to the police officer and says that I have committed this crime. If that is the case, that the FIR is of a confessional nature, then the same shall be hit by Section 25 of Indian Evidence Act, which is any statement made in the presence of the police officer is is not reasonably to be believed. Okay, if the accused comes to the police and gives the FIR, puts this criminal law into motion, but this FIR is of not a confessional nature, the same is admissible. Where? Under Section 8 for motive, preparation, conduct, subsequent and previous conduct ke liye, under Section 32 and under Section 21 of Indian Evidence Act. So today we have seen what is FIR, what is the object of the FIR, what are the essentials of the FIR, what is the basically what is the mandatory guidelines given under the cases of Lalita Kumari and State of Haryana versus Bhajanlal, provided for the registration of FIR, and along with it we have seen what if there is a delay in causing FIR, what is the evidentiary value of FIR. Thank you.